In your musical journey, you will have to take care of legal business at some point. I'm talking about agreements with producers, agreements with record labels, agreements with publishers, agreements with business advisors. For this and more, join me as we take on contracts in music. My name is Eunice Kavere, and I'm a partner at Lumallas Achieng Kavere Advocates. I have been a commercial lawyer for 14 years, and this week I will be your host.
Copyright is a body of laws that developed as a result of the need to protect the creator of the works from having their creations exploited by third parties without receiving any benefit from the exploitation. And trademark is applicable to logos and unique names or even band names. So, for example, Sauti Sol. And using a portion of a sound recording in creating a new work is called sampling, or in legal speak we would say it's a derivative work. Should you do it? Yes, I think it sounds great. However, should you do it without permission? No. So here is where I give you food for thought. There are many resources online that enable you to have just a little snippet of what it is you need as a musician. So one of the classes you could take, you could go to Coursera and take a course there. And the other thing you could do is go to copyx.org and actually take a copyright course. And it's a free course, and all you have to do is just sign up and actually do the class.
Still related to collaborative work. So when the album is played on radio, which rights are entitled to the royalties?
The person who wrote the song, the person who performed on the song, the person who owns the sound recording. So those are the three. So like in Kenya, those are the three groups of people who collect royalties. So Kenya Association of Music Producers for owners of sound recordings, PRISC, Performance Rights Society of Kenya, which is now the performers, the person who sings, the person who's on the guitar, the person who, all those people who performed on the song, and the composer and the arranger, MCS-K, currently, before it was Mpake, but yeah, MCS-K, Music Copyright Society of Kenya, would collect on behalf of that. And then, of course, the split sheets would then inform how those royalties would be shared between those.
Now that we know what sort of rights you have in a sound recording, we can then talk about how you can enter into contracts to provide for how those rights can bring some money to you. Okay? So when you have a copyright, you can license anyone to make use of that right. Okay? Licensing simply means that they have a right to do whatever you have authorized them to do under the license agreement without parting with the ownership of the particular right. Now that is different from actually transferring the copyright. When you transfer the copyright, you're no longer the owner of the copyright. That's the biggest difference between transferring and licensing. So today we are going to talk about some of these agreements that you may enter into over your copyright. Contracts are very important because they spell out what rights and obligations that parties have over your copyrights. For example, suppose a party hires you to simply come and play a line in a song, a guitar line, or to simply come and do backup vocals for a song, and then you agree that they will pay you X amount of money and you part ways, okay? Or let's say a company wants a jingle, an advertisement jingle, or they want a theme song for an event that they are hosting. So you enter into an agreement and they tell you exactly what the scope is and what kind of words they want in that song that you're creating, and then you part ways. We call those works for hire. And it's very important for you to read the fine print, because some people enter into such contracts thinking that they are going to have a copyright to the works that have been created. A copyright owner has the right to either license or transfer their copyright. When you're licensing a copyright, you're simply giving a third party certain rights over your copyright. You're giving them power to maybe reproduce, power to make derivative works, power to do all sorts of things that you can do with your own creative works yourself for a fee. But it doesn't mean that you have parted with the ownership to those works. When you transfer your ownership, you're actually giving up all your rights to your copyright, and you're assigning that right to a third party. So you cannot come back 10 years later, 20 years later and say, I'm changing my mind. So we cannot overemphasize the importance of knowing exactly what kind of deal are you getting into and obtaining legal counsel to interpret for you exactly what are you signing away. So what are some of these agreements that you may enter into over your copyright? Let's take the example of Mpumi, whom we were introduced to last week. So Mpumi has written a song, she has a melody, and she has lyrics. And so she walks into a producer's office, let's call him C4. And they need to sit down and they need to talk about how they will convert this piece of music into a song that can be then released to the public to make some money. So we advise that they have to have this conversation at this point, at the onset, and not when the sound recording has already been created, because you cannot contract backwards. Okay? So they need to agree on, for example, what is going to be the percentage share in the copyright of the sound recording, and what really determines the share of this could be exactly how much work has gone into creating the sound recording, exactly how much weight can you accord to each party in creating the sound recording. For instance, some producers will actually write a little bit of the lyrics to the song, and they will sometimes they will change the melody. Okay, some producers will take care of the costs, the studio costs, the mixing and mastering, giving musical direction, just taking charge of the creative side of creating this sound recording. And therefore, when it comes to negotiating exactly what is going to be each party's share, then we have to take into account some of those things. Who catered for the costs of this? So if the only thing you brought to the table was your lyrics and your melody, and the producer then layers it up with a beat and makes sure that all the elements are working harmoniously well together, then they really have a larger stake in the sound recording. So this is exactly what you will be discussing with your producer. And once you have reached an agreement as to the weighting of the rights in the copyright, you will come up with something that we call a split sheet. And so this split sheet will be saying the artist will be entitled to 12.5% or 50% of this. And when we are saying 12.5, what is the relevance of these percentages? So this split sheet is going to be registered with the collective management organizations. In Kenya, we call them CMOs. And therefore, any royalties that are going to accrue to that sound recording are going to be split between yourself and the producer and whatever other party there may be in the ratio that you have agreed upon in your copyright split sheet. Okay? So now you have a sound recording and you need to monetize. Besides just registering the copyright split sheet with the CMO. We have other parties in this industry. I'll be looking at the publishers and record labels. When you approach a publisher, what exactly are you looking for? A publisher simply finds uses for your music so that revenue can accrue to you, and then you can share that revenue with the publisher in the ratio that you will have agreed upon. So a publisher will be trying to find you public performance royalties. They will make sure that you obtain public play, whether it's in nightclubs or live concerts, or you have airplay on television or on radio. And then this revenue is collected by collection management organizations. Another stream of revenue could be mechanical royalties, and this is revenue from reproducing your sound recording, say on CD or for digital streaming. Another revenue stream is synchronization license fees, and this is when you get your sound recording incorporated, say, in a movie or any audiovisual works. And finally, print license fees, where you have your score music being sold. Although many artists are independent artists, it brings you great value to have yourself signed by a record label. What are the key things that you're looking to have in your agreement when you're negotiating an agreement with the record label? First of all, you will have to understand exactly what kind of rights are you giving the record label company. How long are you giving them those rights? Do you have an agreement on the number of songs that you must write within that term, or the number of albums that you must have out within that time? Have you agreed upon the royalties sharing formula? Is it 90-10, 50-50? Have you agreed upon the territory within which they need to market your music? Is it just your country? Is it worldwide, or is it regional, say Africa? Have you agreed upon the recording budget? And have you agreed upon how marketing and promotions is going to be done? These are the salient things that you must agree upon when you're negotiating your agreement with a record label. This section is going to address those of you who are in bands. I have a question for you. Do you have a band agreement? What is a band agreement? How have you registered yourselves as a band? These are the questions that you need to ask yourselves way before you form the band, or at the point when you're forming the band. It's very key to know, how are you going to market? Are you registering yourselves as a partnership, or are you registering yourselves as a limited liability company? Secondly, you need to address the issues of intellectual property in the name of the band. Who owns the name of the band? Who owns and controls the copyright in the name of the band, or any other copyrights that accrue to the band? How are you going to be distributing the income and assets between the band members? Who is your band leader? What are the responsibilities of each band member? What will you do when one band member leaves, or when the band stops existing and you no longer want to continue as a band? How do you resolve disputes? It is for this reason, or the questions that I have just posed to you, that you need to sit with your legal counsel for them to draft you your band agreement that gives the band position on each of those aspects. The last class of contracts that I want to talk about are contracts with the managers and agents. Personal managers, as the name suggests, are basically there to manage you, to deal with your publicity and public relations, to advise you on your career development, to give you wise counsel when you're negotiating contracts before you enter into them. How do you pay your personal manager? You have to negotiate that in an agreement. But the standard practice is that you pay them a percentage of your gross earnings. Another category of contracts is a contract with your agent. Your agent simply finds gigs for you and you share the revenue that he brings to you. The last category I want to talk about are business managers. These are people who handle your finances. For example, they make sure they file your taxes, they make sure your bills are, you have paid your bills, and you pay them not as a commission from your earnings, but an agreed fee or an hourly rate. You may have noted a common thread in our conversation today, that you really get out what you put in. The contract is the superior document that governs your relationship with all the categories of third parties that we have spoken about. And therefore, our advice to you is that no deal without your lawyer. Let your lawyer read the fine print before you sign any legal document.
Someone was asking about the songwriting and if what he feels about the beats, and if somebody has not added, he feels that somebody hasn't added value. So this question is still continuing from Kevin Hihu. He says, what if I actually I write a song? What happens if I write a song for someone and they use it without us having a contract? So there's nothing in writing. What happens?
If you recall the lesson 1 with Wanderi, and she was breaking down the basics of copyright and telling you exactly when does copyright accrue. You have your original idea, you have expressed this idea, and the idea displays a degree of creativity, and it has been stored in a permanent form. Whether or not you have registered with Kikobo, your copyright accrues in your work automatically, and nobody can sign you out of that. And even when you assign that piece of your copyright, even when you assign your copyright, you do not lose your moral right, which is the right to be credited for your work. And so if someone stumbles upon your piece of music, uses it without your permission or your consent, then that is copyright infringement, and you can get remedies from court for that. The court can give an injunction against the continued infringement. If you can prove the damages suffered, the court can award you damages. Therefore, you have a right, whether or not you have entered into an agreement. Nobody should avail to themselves your copyright without your consent.
So that's the point that we start talking about dispute resolution. And a last question from Felix Kimanthi was about, do lawyers do dispute resolution? What would you advise about dispute resolution?
Absolutely. Lawyers have the capacity to resolve disputes. Anyone really in a position of authority can resolve a dispute if the parties give him that power to resolve the dispute. Perhaps I should not say too much about dispute resolution, because you need to come back next Tuesday when Paulette will be taking you through dispute resolution. But to answer your question, Kevin, yes, lawyers can resolve disputes.
So we have another question all the way from Zimbabwe. Edith Wiltonga asks, does the producer go on the split sheet if he has been paid already for his fee?
I don't know how many times I have to explain this point, that the fact that you have received money does not disentitle you to your moral rights, to your creative works. So a producer is not paid royalties only. You know, there are other benefits to there's consideration. So when you come and sit down with your producer and this is what you want to do, and everybody has agreed upon what their obligations are to get the sound recording out, there's going to be a money conversation. I mean, studio costs money, hiring of equipment costs money. There's a money conversation that you will have to have. Now, over and above what it has cost the parties to come up with a sound recording, they also are entitled to a copyright in the work because of the creative addition that they have made to the sound recording. And therefore, yes, the producer will be on the split sheet, whether or not they have been paid. Unless, of course, you have agreed otherwise. If you agree that the producer will not be on the split sheet, well and good. But if you do not have the conversation, then perhaps the only vague thing will be what will be the shares, but indeed the producer will have a right in the sound recording.
Thank you, Kavere. And I think that also goes to answer her second question, which was, in the event that the producer has already been paid a flat fee at the onset of the recording, do they still go on to appear on the split sheet? And I think you've given us a very elaborate answer on that. So Maija of Rivenberg, Kipepeo Agency, asks, what are some of the things to look out for in a licensing contract?
Okay. I will start by asking, do you really know what licensing is, as opposed to transferring, say, your rights? So in the first lesson, or rather session, we spoke about copyright. What is it? And what rights accrue to you as a result of your having created a piece of work, piece of music. And the moral rights, which are the rights that you cannot sign away, are the rights to actually have the last word in determining exactly what fair use your work is put to. And I recall Wanderi giving this example that you can create a piece of work and say, I do not want my music to be used in a blue movie. That is your moral right. You can say, I want my works to be associated with this kind of thing and not this kind of thing. What was the question again?
So the question was, what are some of the things to look out for in a licensing contract?
Okay. So licensing actually attaches to the moral rights, because then, whereas you have a right to determine to what use your copyright shall be put to, then you also have a right to then give somebody else this right under a license agreement and tell them, I'm allowing you to do this, I'm allowing you to reproduce, I'm allowing you to make derivative works, or I'm allowing you to reproduce, but I'm not allowing you to do translations, I'm not allowing you to do derivative works. So the license agreement basically will spell out everything you want to give permission to another party to do, and reserve to yourself the rights that you want to reserve to yourself. So it would really be a very long conversation if you went into each and every item, but those are the key features. That what rights do you want to grant on assignment? For how long? Is it perpetual, or is it only for 5 years? Is it only within the territory of Kenya, or is it worldwide? So that is a conversation you must have, so that you determine exactly what you're going to put in the license and what you're going to license to a third party and what you're going to reserve to yourself. And for how much? The most important part is for how much.
Yes, music is a business. It's actually interesting, Kavere, that you talk about perpetuity, because Mutuku Mudhama is asking, are there some terms or words, for example, perpetuity, that people should be aware of when signing contracts in the music business?
Yes, in fact, if you see the word perpetuity, if you do not have a lawyer and you just see perpetuity, just circle it and ask that it be removed from the agreement, unless you really, perpetuity simply means forever. And I don't think we are able to determine forever positions in the present. So it is good to give room to extend, but not give an outright right ab initio. Ab initio is from the beginning, from the onset. Do not give away your rights in perpetuity from the onset. be in the habit of giving timelines and giving room to extend. If things are rosy, then you can always come back to the drawing board and extend the term of the agreement.
So what I get from you, Kavere, is put everything down in writing. First, know your rights. Second, negotiate. And third, put it in writing. Now, somebody asked, do CMOs sign contracts with artists?
No, CMOs, first of all, they have the authority, perhaps under an act of parliament, to do the work that they do. So they are the ones who owe you as an artist to do the work that they ought to do. And they get paid for the work that they do from your earnings, from your work. Nobody pays CMOs money to do the work that they do. It is your hard sweat of your brow that enables CMOs to do what they do. Now, what do CMOs owe you? Obviously, they owe you to pay you your royalties. How will they know how much royalties they need to pay you? You will have to tell them. How do you tell them? You will have to register your split sheet, your copyright split sheet with them, so that they know if they collect 100 shillings on this song, then 20 is going to so-and-so, 50 is going to the artist, and 10 is going to so-and-so. That's about the contractual relationship you will have with your CMO. Otherwise, they need to be impartial and they need to serve everyone equally.
We have a lot of children who are artists, underage, basically minors. Do they have capacity to get into contracts? What would you say about capacity, and should we be careful about, as artists, in engaging minors?
Yeah, children do not have contractual capacity. It doesn't mean that they cannot be creative. I think they are the most creative category of, that's when their ideas are very fresh and innocent and undefiled. What you need to be very careful about in engaging children is you have to ensure that you speak to their representative, their legal guardian. That's the person who has the authority to bind that minor in an agreement.
A lot of the time we engage minors without understanding that this is a vulnerable group of people, and therefore there needs to be some form of consent from whoever is in charge of them, and therefore we need to be very careful about such groups of people. I get another question that says, what happens once copyright expires? You see, in many jurisdictions, we have copyright maybe 50 plus years, maybe 70 plus years. What happens to the copyright then?
Well, this will begin another conversation on succession. I think you ought to figure out, as long as your copyright subsists in your work, whether you're alive or dead, you need to think about whom do you want to gift your beautiful gift of copyright, and act accordingly. If you want to have this in a will, then you ought to have that in a will and say, upon my death, all the royalties or income coming from licenses and what have you, based on my copyright in this and in this and in this, I want to bequeath so-and-so, my son, my spouse, whoever it is you want to bequeath. If you do not do that, then the law of the land will take shape based on whether you're a Christian, a Muslim. There's specific succession laws depending on those special groups. But the general practice is that it will devolve to your estate and it will be distributed in accordance with what the law says. So if there's no will, if you're the artist, you have a spouse, you have children, your spouse gets a lifetime interest, an interest for as long as the copyright subsists, and then your children are the ones who get the benefit of it equally, whether they are born within wedlock or out of wedlock. But like I said, that's a whole succession conversation. What is important as a take home for today is that you need to think of your copyright as an asset, just like any other thing, just like land. or a house, and plan for how you're going to transfer it in the event of your death.
So I can see there are very many more questions coming in. I think we can take the last 2 questions before we can wind up. Maija Rivenberg asks from Kipepeo Agency, is 50% a normal fee for a licensing company? Someone told me it was, but it seems very high to me.
If there's something that we have said over and over, there's nothing like standard. It is what you negotiate, put your points on the table, say why. Like we had the other gentleman who was saying, I don't think simply putting a producer simply doing, adjusting the beat is something weighty to my sound recording. So have that conversation. So there's nothing like a standard position. You have a conversation and you agree on how you're going to split the copyright.
Another question on minors again, and Felix Kimathi is asking, if a minor did a song and the song was registered to his or her mother, for example, and they turn 18, do the rights automatically transfer to the child, or do they have to go to court or CMO or someone else? What happens in that instance?
They don't need to go to court. When someone is holding a right in trust for a minor, it ought to automatically revert to the minor upon their attaining the age of 18. However, I don't think CMOs keep records of when minors are turning 18. So it will just be a good next step to go and have the records updated to show that the minor is now able to receive their own royalties in their own name now that they are 18 years of age.
I can see the questions are still coming in just as we are about to end. But this one is interesting. It says, from this conversation, I'm picking up that for performers in the bands, they will need to be registered with a CMO in order to benefit from the royalties. Is that correct?
That is not correct, because the CMO will not, whether you register with a CMO or not, and I hope this person is not misusing the word register with a CMO. So let me put it this way. If you have done collaborative works, you're a band, make sure that the copyright split sheet has your name and it shows what percentage of the copyright accrues to you, and then have that registered with the CMO, because the CMO will not know. There's no magic for them to know that they ought to pay you some of the royalties that are accruing to the song that you guys have done as a band.
Thank you so much, Kavere. Our last question for the evening comes from Macau, and it says, how do you copyright scored music?
Now, the shit music, I once had someone saying shit music and they were spelling it S-H-I-T. No, it is S-H-E-E-T. It is actually copyright in terms of the underlying music, as well as the shit itself as a literary work. So that's how you copyright. You simply register the shit. Yes.
Thank you so much, Kavere. I think our questions on dispute resolution will be tackled best in our next session. And we thank you all for participating, and we hope you can join us next week.
Kama kawa, kama dawa. Tuesday, 3 p.m. See you then.